Sorry for the delay, everyone. It's my fault. We'll just wait for Commissioner Sullivan. Oh, there he is. Commissioner Sullivan, did you hear that? I said, I'm sorry we're late. It was my fault.
I will never forgive you.
Okay. Good morning, everyone. Welcome to the agenda meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben, the chair of the commission. I'll take the role of the other commissioners who are participating in today's hearing. Commissioner Hom.
Here.
Commissioner Tuma.
Here.
Commissioner Sullivan.
Here.
A quorum is present, and we have 2 items on our agenda for today. Mr. Duran, will you please introduce the first item?
Good morning, Chair Sieben and Commissioners. Item number 1 is docket number 16521, involving all electric utilities in the matter of updating the generic standards for interconnection and operation of distributed generation facilities established under Minnesota Statute 216B.1611. The question before the Commission is, should the Commission approve the technical subgroup's proposed changes to the State of Minnesota Distributed Energy Resources Interconnection Process, the MINDIP, regarding adding new study screens for unintentional islanding? There were no late filed comments or decision options. Staff notes an error to the briefing papers. This was a docket related to all electric utilities, not just Xcel Energy, as was indicated at the top of the document. Parties are available for questions, and staff has no additional comment. Thanks.
Okay, thank you very much, Mr. Duran. We'll start with questions from commissioners on this. Commissioner Tuma?
Madam Chair, I don't need to hear from all the parties, but I think I'm inclined to support number 4 on the decision options and all the A, B, and C subparts. I think it's wise to take a good look at this over the next couple years. But it wasn't clear on my record if anybody objected to it, so I don't need to hear people coming and supporting, but if there was anybody of the utilities or whatever that might object to IRAC's recommendation, come forward and tell us your concerns, but I don't need to hear from you, and it's kind of one of those deals where silence would be golden. So if nobody comes forward and has a concern with it.
Good morning. Welcome. Please state your name for the tape.
Good morning. This is Brian Munson with Xcel Energy. Madam Chair, Commissioner Tuma, we don't have any strong opposition to 4. We just feel that it might be a bit unnecessary given that the TSG has made its recommendations, and that should down the road parties feel that have concerns with how the screens are being implemented or want to see changes made, they can bring that forward to the DGWG at that time.
They always, in other words, they always have this right to do this at this stage. Correct. I think that's the only thing that really adds to it is we like to have at least 2 years out. Let us know how it's going. That's really all this adds. Yep. So you're not really objecting to that. It's just probably not necessary.
Correct. Yes. Yep.
Mr. Munson, could you explain how, or could you just confirm that the actual linemen who do this work are supportive of the changes that are outlined by the in the MINDIP, or I mean that are changes that are outlined to take place in the MINDIP, that the actual folks on the ground, from your experience, are going to be supportive of this change?
Yeah, Madam Chair, that's correct. We believe that these screens are important for ensuring the safety of our line crews when they're working in the field, to ensure that lines aren't energized when they're not aware of it as a result of unintentional islanding.
Mm-hmm. And so this is this, and do you have any knowledge, is this like a practice that happens across the country too, or should any insight into, I know it happens very rarely, or that's my understanding at least, but any idea of whether the changes that are proposed are things that other utilities across the country are doing?
Madam Chair, I believe that the screens, or the concept of screens, and looking for the risk of unintentional islanding is a common practice. As to whether or not such instances have actually occurred operationally in the field, I can't personally speak to that.
Seems like overall the changes are good, and we thank all the parties for working together to come up with these recommended changes. Is there a motion, Commissioner Tuma?
Yeah, Madam Chair, I would move decision option 2, 3, 4, A, B, and C, and 5. And understanding anybody can bring forward problems at any time, but it'd be nice to have a look in a couple of years on it.
Great. Is there any discussion of Commissioner Tuma's motion? Hearing none, then we'll vote. Commissioner Hom?
Yes.
Commissioner Tuma?
Yes.
Commissioner Sullivan?
Yes.
I also vote yes. The motion passes 4-0. Thank you.
Thanks. Thanks for the good work.
Good morning, Ms. Marcus. When you're ready, please introduce item number 2.
Good morning, Chair and Commissioners. Item number 2 involved Northern States Power Company doing business as Xcel Energy, and docket number E002 GR23413 in the matter of the application of Xcel Energy for authority to increase rates for natural gas service in Minnesota, and docket number G002 GR23412 in the matter of a petition by Xcel Energy for approval of a new base cost of gas. The question before the Commission is, should the Commission accept the offer of settlement and adopt the Administrative Law Judge's findings of fact, conclusions of law, and recommendation to approve the settlement? Staff and parties are available for questions.
Thank you, Ms. Marcus. If the parties could come forward for questions. We'll start with Xcel. Good morning.
Morning, Madam Chair, Commissioners. Ian Dobson with Xcel Energy.
Go ahead, please. The department.
Morning, Madam Chair, Commissioners. Greg Mertz, Assistant Attorney General, representing Department of Commerce. Here with me this morning in the hearing room is Nancy Campbell with the department staff, and we also have other department staff available online.
Good morning, Madam Chair, Commissioners. Brandon Crawford with the Citizens Utility Board of Minnesota.
Good morning, Madam Chair, Commissioners. Joey Cherney with the Office of the Attorney General, Residential Utilities Division.
Okay, and Ms. Brahma, welcome to your representing Xcel.
Yeah, thank you, Chair Stephen.
Great. For Xcel first, if we could just start with the overall, Mr. Dobson, do you have any rough estimates of what the refund amount will be for customers after final rates are implemented?
Yeah, thank you, Madam Chair, Commissioners. We have our compliance filing out now that the department, I think, is still reviewing with respect to our sales. So assuming that they don't have any adjustments to that, we came in pretty close. We're looking at about $1.5 million refund that we're projecting right now.
So it will be roughly the same as interim rates?
Yep, very close.
Okay, and actually, other commissioners, do you have questions on the overall rate case or parts of it? Commissioner Sullivan?
I just had a question for Mr. Dobson. I want to go to the decision option that Xcel would like us to modify. That's decision option 115. And I just would like him to, Mr. Dobson, if you could explain a little bit. I feel like you're changing happies to glads. I don't really know what you're doing here. Feels like the changes are identical to the original language, so help me understand.
Thank
Mr.
you.
Dobson?
Yeah, Madam Chair, Commissioner Sullivan, it's not intended to reflect any material change. It's just the change in the grammar from what we withdrew to what are being changed. I think the original proposal suggested we were making several withdrawals, and there are changes that are being made, but it's mostly a clarification. But there isn't like I said, there's not a material change.
So then, if we were to accept your change, then that, I'm just trying to get my head wrapped around what we have to do then we have to make changes to decision options 901 and 902, don't we then? Or no?
Well, sure. I think we're getting sort of into decision options. I think what I'd lay out is I think the parties base are that I completes all of this is that you would do decision option 115, and then 901, and then the
Don't we have to do decision option 2 though if we do your 115, because 115 is a modification?
But 115 is a modification to the ALJ report, not the settlement. So number 1 would accept the settlement. Then there's a modification not to the settlement but to the ALJ report. So that's why we think we can do both of those. And then you would do 901, and then the department has actually a 901A that we've agreed to that is slight modification to 902. So you do 901, 901A, and then 903 through 905.
Then your 115, 901, 901A. And what was the last one you said?
903 through 905, which is the housekeeping.
903 through 905. Okay. Okay, thanks. That was all I had.
Commissioner Tuma?
So in other words, you have some language just to shoestring in.
Yeah, Madam Chair, Commissioner Tuma, it's actually the department's language, but yeah, we've looked at it.
Mr. Mertz, why don't you just give us the language so we know what it is?
Sure, and I provided a copy to your staff, and with your permission, we could just put it up on the board, and I can explain what it is we're doing and why we think this change is appropriate. As part of the settlement, the parties agreed that they would use actual sales and actual customer counts in establishing baselines for rates, but that information wasn't available at the time the parties entered into the settlement. It is now available, and so it will be incorporated into the settlement. And so what we're doing with 901A is just making clear that that there will be an adjustment in the schedules, and that will be filed as part of a compliance filing. The department is now in the process of reviewing the actual sales data that the company has filed, and we expect that to be completed fairly shortly. But you'll see here just that we are saying just that thing, that if the financial schedules will be adjusted to reflect actual sales and customer data.
But isn't that incorporated in the settlement? That's the part that I'm trying to understand.
Well, the problem is with the way the decision option is written. So 901 says if you don't make any changes to the settlement, you're going to adopt the schedules. Well, that's not quite right. You're not going to adopt the schedules as they stand now. The schedules are going to be reflective of that actual sales information.
So we don't need to change 901. We adopt 901, and then 901A
Correct.
allows the schedules to be updated in accordance with the settlement.
In accordance with the party settlement, that's correct.
And we don't need to worry about the minor change to 96 of the ALJ's order. That'll be incorporated in all this, and also would be incorporated in 905 because the executive secretary has authority to modify the ALJ's order reflecting that.
Right, and as Mr. Dobson noted, none of that requires any change to the settlement. So,
And the 906 change you're suggesting has no impact on any of the schedules whatsoever, is my understanding.
And do we have 901A? It's just up on the screen, Ms. Marcus.
I'm sorry.
I just want to make sure with Commissioner Sullivan online, we don't have it anywhere else. We're just looking at it now live, right? Right. You got that, Commissioner Sullivan?
You have it electronically, so you could email it to him, or?
Yes, I was scurrying around looking for it, so if you could, I could see it on the screen, that'd be helpful. I see it here. Okay.
Yeah, I think they're going to try to email it to you, Mr. Sullivan, so.
That's okay, I got it here. Email's fine too. That's good, but I can see it.
Okay, or Commissioner Hom.
Thank you. I don't know what is overall question, but I'll ask Department COP and OAG of their rationale supporting this. And do you have any other idea? I can follow your process, but that's my intent to ask this time.
Yeah, do you think that the proposed change still is in line with the settlement too, right? Or do you have a different question?
No, I just want to ask overall why they signed this settlement.
Oh, okay. So moving past 901A then. Yeah. Mr. Mertz, would you like to begin?
Thank you, Chair Stephen. Commissioner, this represents a compromise. We believe a compromise that is good for the citizens of Minnesota. It results in rates that are lower than had initially been filed. Did the department get everything it wanted? It did not. And I've never settled a case. I've settled a lot of cases, but I've never settled a case where I got everything I wanted. We believe this is a fair compromise, and we support it in all of its respects.
Thank you. Along that line, what is the issue you stand by with your position, and what is your position moved away to settle this?
Well, I think there are a number of compromises that are reflected in the ALJ's report. We did end up, for example, with a ROE that's higher than I think we had initially proposed. That represented a compromise on our part.
Okay. What is the rationale that you're giving up your ROE position? In return, giving up that ROE return, what did you get?
Well, there were a whole lot of issues that were and I don't know that I could pick any particular one. That's the one that we traded for ROE. I don't think this settlement works that way. What we were saying is if you take kind of the parties' respective positions and the endpoint that we ended up on was one that we thought was fair. We don't obviously know how this case was going to turn out if it got tried, and that's a big reason why parties settle. So I don't have, there never was, I don't believe, sort of a one-to-one, we'll take this issue, you take that one. That wasn't the approach that the parties followed in resolving this case.
Yeah, that's why I got an impression out of this, even though it's pretending that a black box settlement. Seems to me it is black box settlement, because I don't see that kind of rationale.
Well, each of the elements of the settlement is clearly reflected in documentation that has been filed with the commission. So I wouldn't call it a black box settlement. I would say that the justification for why each of the elements of the settlement is reasonable is set out and reviewed in the ALJ's order, and has also been reviewed and discussed by your staff in preparing their briefing papers.
So are you saying that your staff, the ROE position wasn't reasonable in the beginning when you are writing that testimony? That's why I want to know why you had to give up that ROE position, given that your staff did their best to support their position.
What I would say about that is we do believe that the position that we set out originally was appropriate. We also believe that it was a position on which reasonable minds could disagree. And we don't know where those reasonable minds were going to come out at the end of the day. And so looking at the settlement globally, again, I wouldn't pick out any particular element as that's the thing, but looking at the settlement globally, we believe that we got a good deal for the people of Minnesota.
Are you aware that your decision to give up your position, even though it's a 20 basis point, has a long-term impact in the ROE decision in the future.
We certainly reviewed all aspects of the settlement and how it would affect the people of Minnesota.
Okay, so are you comfortable that because ROE is based on the comparable group, if it's trending up, that it's very difficult to stop that trending up? You are potentially contributing to that ROE is going up in overall in the industry by agreeing with the 20 basis point more than original your position then.
And what I would say is Xcel had proposed, I think, a 10.5% ROE. So it's not as if, again, it's not as if we caved in. It's not as if we gave up our position. We realized that there was at least some potential that we might end up higher than where we landed. So that wasn't a risk that we thought was justified. Again, and I keep saying this because it's important not to lose sight of, it was justified in terms of the global outcome of the settlement.
I understand value of the settlement. I'm not discouraging settlement, but I want to have more information. Even if you settle, I want to have a rationale because I respect those witness and staff writing that testimony. They do that work very seriously. When you are taking that position down, I want to have some rationale, and even I want to see whether they are supporting it or not, but it's up to you because it's your agency, how you operate it. But I want to see at least some analytical rationale that why you can give it up.
I'm going to ask Ms. Campbell to come to my obviously needed assistance here.
Good morning, Ms. Campbell. Please state your name for the record.
Nancy Campbell for the department. I'd just like to add that the commission approved a 9.57 ROE in our last rate case settlement. So 9.6 is not a lot, not significantly different. Additionally, I'm the supervisor of the financial analysis unit, and our witnesses, we ask about, like for ROE, we ask people like Craig Adonisio, who is our expert witness on this, if he's comfortable and he thinks it's a reasonable amount. So we're not just doing it at will. We're asking and getting that input, because that's the way we do settlement. So if that makes you feel better.
Thank you. That's what I want to see in the document, whether you had a chance to ask your witness whether they are comfortable or not. Thanks for that, giving me that information. That's why I said this looks like a black box settlement, because I didn't see that kind of rationale, and whether there was a cross-checking from your professional expert witness within your agency. If there's that kind of a check, I'm more comfortable agreeing with overall settlement.
I appreciate that. And I will note, I feel like this is the exact opposite of a black box settlement, since we step by step went through every single issue. So, and we'll always do what we think is in the public interest.
Okay, thank you. Unless department has anything else, I can move on to the next.
If you're satisfied,
Yeah.
Commissioner, we don't have.
No, I have a more detailed question, but it's overall, settlement question. So,
I understand.
thank you. That COB, same question. COB historically and also recently, COB issued newsletter saying that you are taking very strong position on the rate of return. Why did you sign this overall settlement that is moving away from your ROE position?
Mr. Crawford.
Madam Chair, Commissioner Hom, we do support the settlement agreement, and we do look at it as a global settlement. There were a lot of elements that reduced that overall revenue requirement for the company, including a substantial reduction from what the company was originally asking for ROE. Yes, it was an increase from the previously authorized return, but we looked at that together with all the other various factors, including reductions for trade organization dues, which we had advocated for, the executive compensation reduction recovery that OAG had advocated for. And we saw that together with the the modest increase to the ROE, and we saw the global settlement as something that was more reasonable for customers, and we viewed it as being in the public interest.
Okay, thank you. So your agency also understand that ROE alone cannot explain overall rate case impact to the ratepayers.
Madam Chair, Commissioner Hom, we do understand that. We do recognize, though, that ROE does have an outsized impact, and all of the various factors included within the rate case contribute to the value that's being recovered from ratepayers through that ROE figure.
Okay, thank you. And the same question to OAG.
Madam Chair, Commissioner Hom. As you know, the OAG is always concerned about the impact on ratepayers when utilities raise rates. These are basic necessities and they have to be affordable. This settlement results in lower increases for residential and small business ratepayers than Xcel proposed, and is supported by the record. In particular, our revenue apportionment and rate design recommendations, which were very important to make sure that things stay affordable for residential ratepayers and small businesses while mitigating any potential rate shock to other classes. So overall, again, you're discounting the risk of litigating something all the way through versus getting your important issues in settlement, and we view this as, a just and reasonable settlement.
Okay, thank you. In that statement, isn't it better if you shrink the size of the overall revenue requirement rather than you shift some of those burden to some other class? Because maybe overall net impact may be better for the residential customer, but for the overall, isn't it better if you take a position to limit ROE or overall size of the increase rather than you focus on the shifting, focus on CCUSS, basically?
Yeah, Commissioner Hom, that's a good question. I wouldn't necessarily say that one is better or worse than the other, right? They're looking at different important parts of rate design. We didn't have a witness speak to ROE, so that was something where we were really deferring to the Commission and Commerce and CUB on. The reality, of course, of rate design is that you can be shifting millions of dollars of costs between different customer classes. And in our opinion, the way that Xcel had proposed to do that apportionment was really inequitable for residential and small business ratepayers. And so, according to our CCOSSs, which is what's reflected in the settlement, it's much more adheres to cost causation principles it adheres better than the original proposal.
Okay, thank you. The reason I raised this issue was reading the record and talking with our staff. I think our staff felt that there are not enough information why you guys settled, even though it is not black box settlement. There are not enough information for our staff to chew on and then tell us what's going on. So that's why I was asking this global question. I'm not discouraging a settlement, but I think we need more information from you that what is the rationale, rather than you say a global amount is good. That is a black box settlement. It has to be issue by issue why you can move away from your position. I think without that, I think our staff cannot understand why you guys are settling. In our view, it becomes a black box, even though it's not a black box.
Commissioner Sullivan.
Thank you. I got a question for CUB. Mr. Crawford, I'm a little bit annoyed with CUB about recently, and I mean, I'm glad you're part of this settlement, and I think it's important that everybody came together. But a recent newsletter of yours, you guys boosted a report that was it's about rate of return equals cost of capital. That was what it was titled. And in that report, the author cites to the Minnesota Commission, and it's like around page 14, under the section corruption. And he's referring to the last Xcel rate case. And he cites to actually a Minnesota ALJ decision, not a Minnesota Commission decision. And, I do want to note that you guys boosted to that, or you guys, highlighted that. You put it in one of your monthly mailings, referring to that. And, you're here right now settling in a case that is above the cost of capital, so on the ROE issue. So I just want to let you know that. I'm annoyed about that. I have I'm going to tell you that in public, and you feel free to respond.
Mr. Crawford.
Madam Chair, Commissioner Sullivan, the reference to that and the linking to that was in no way to say that the Commission is involved in corruption or anything of that nature. We do, our expert testimony in several recent rate cases has pushed for a greater correlation between the return on equity that is decided by the Commission is based on that cost of capital, and linking those two together, we do believe is a much more reasonable and appropriate weighting of how to determine that return for the company. And I haven't had a chance to look at the specific language you're referring to, or the heading under which that statement is made. We recognize, and this has been included in Steve Keim's testimony regarding the kind of how return on equity has been evaluated across the country for a number of years. We recognize that this is a change, and we're asking the Commission to start to look at this in a slightly different manner, and in no way was linking to that meant to be anything negative towards the Commission. So I apologize.
Thank you. And I would just ask in the future that you be, I recognize your policy advocacy organization, and I appreciate and respect the work that you do. But I would just ask you to, when you're boosting something or you're pushing it out to your membership, when you have a significant number of people who are maybe not necessarily members, but who are watching you and are on your mailing list, folks will read that, and I'm concerned they'll get the wrong opinion or the wrong perspective if they read it on their Public Utilities Commission. But thank you for your comments there.
And Mr. Crawford, to be super clear, CUB did support the ROE that is recommended in the settlement, or as part of your recommendation for the Commission to improve this rate case, you're supportive of the ROE that's adopted in the settlement.
Madam Chair, that is correct.
Okay. Any more on that topic? Otherwise, I did have a question for Xcel about your tier 1 and 2 gas, what's it called? Not rate, but interruptible service, or the change. Could you just give us a general overview of it, Mr. Dobson, of how it's going to work and how I think it will result in in a more reliable system overall.
Yeah, thank you, Madam Chair. I'm actually going to have Lisa Peterson come up to speak to that.
Ms. Peterson, welcome. We had a interesting planning meeting on Tuesday, and then I read this little snippet and thought it was linked to that. So if you could just talk about the new tier 1 and 2, I can't find it in here. I don't know why I'm calling it a system. It's not a tariff. If you know what I'm talking about, if you could explain it, please.
Good morning, Commissioners. Lisa Peterson with Xcel Energy. So in this rate case, we proposed previously we've had an interruptible program that we have called for what I would say the majority of the calls have been for, we've curtailed for reliability purposes. In working through the Winter Storm Uri docket and issue, one of the things that came out of that docket was the call for us to make more clear that we can interrupt at any time for any reason, and I think we changed our tariff language in this case for that, as well as offering another level of curtailment for economic purposes. So we have been working with our operations folks to stand up in that program and make an offering here in this case. So we have I would say a slightly deeper level of discount for customers that want to sign up to be curtailed for either reliability purposes or economic purposes. So depending on, I would say, for the most part, I suspect that if the economics, if the market is such that it is going to a high enough level that we would be considering an economic interruption, it's probably due to weather, and so we would probably be contemplating a reliability interruption anyway. But that being said, we assuming that this is approved, we would have two tiers of our interruptible program for customers.
So thank you for that explanation. The way I read it it's on page 49 of the briefing papers. Thank you, Commissioner Tuma. Essentially, like if you're more open as a large customer to being interrupted, you could move into a tier that would increase the likelihood you would be interrupted, and you would get a better rate overall. But you also have to live with the realization that you're more likely to get interrupted in times for reliability purposes to help your overall system.
That's correct. We would, first and foremost, we would make sure that we're curtailing for reliability purposes. That's the most important part of our system, to make sure that we are providing reliable service to everybody. But we would have that expectation that if called for an economic interruption, that they would also be expected to interrupt under those conditions as well.
And through this will take effect then, and I assume there'll be like outreach to your large customers to help explain that tier 1 and tier 2 system, and then at some point will you be telling us in a compliance filing or in some other docket about the uptake of this? Like, I'm just curious to see how many customers actually sign on to either the tier 1 or 2 level.
Certainly, to be honest, I don't recall what we mentioned here about reporting on this, but there would be a couple of places that we would very likely be able to touch on or report on how many customers are in each tier. And I'm thinking of our AAA, where we report curtailments and frankly non-curtailment penalties and things like that. So
yeah,
yes,
maybe that will be a good opportunity then to see, like, not only how many sign up, but what like how often they are interrupted between the two tiers as well.
Yes.
Okay, great. Commissioner Hahn.
Thank you. Just Stephen, I have a follow-up to that question. So when you say reliability interruption versus economic interruption, so every year you have a demand entitlement, you procure farm transportation above and beyond your need to have a reserve margin, right?
That's correct.
What is your current reserve margin percent for this heating season?
I don't have that with me. I want to say it's about 4.5%, but I don't have it with me.
Okay, so if this transportation customer eat into that 4.5% reserve margin, are you calling it as a reliability situation or economic situation?
We have both firm and interruptible transport customers. So if we're calling our curtailment on our distribution system, we I think for the most part, what we normally do is call our interruptions on our sales customers, and if the transport customers can get their gas to the edge of our system, because they're responsible for getting it to the edge of our system, we oftentimes will transport it to them. If we're in a design day-like conditions, we're interrupting our interruptible transport customers as well on our LDC system.
Okay. Who's paying for that reserve margin? Firm customer or also interruptible customer is paying portion of it?
Firm customers would be paying that.
That's why I'm asking why this interruptible customer is using that portion in case if you are not properly interrupting, even though there is a reliability, when you are eating up above and beyond your design day and you are eating into the reserve margin portion of it, why those interruptible customers paying for that?
Can you state that question in a different way? I think I lost you in there.
So your interruptible customer is using the capacity which is paid for by firm customer, which is a reserve margin portion. You just answered that. Why either you interrupt that customer to not to use that portion because you have to save that portion for the reliability of the firm customer. If they are eating into that portion of it, so you are serving the customer using that reserve margin portion of it, Xcel Energy has to charge that customer and return that money to the firm customer, right?
I'm trying to think. There is a point in time that if we are not fully interrupted, and we keep interruptible customers on the system, we do charge them some demand costs. So we would charge them, I don't know that it's specifically the reserve margin portion. It's under certain circumstances that we would do that.
Is it reflected as a revenue in this rate case?
That all runs through our purchase gas adjustment. So I'd have to look at what the forecasted fuel is in the case.
Okay. Thank you. That's why I think when you distinguish between reliability and economics, some portion, I think is reliability, but you are pretending that to be economic interruption. I think Xcel Energy should either interrupt that interruptible customer if your capacity is above and beyond your firm load, expected firm load, but you are eating into that reserve margin portion. Otherwise, you have to fully charge them and ship that revenue to the firm customer. And I hope that is reflected in this rate case. And if you allow me, I can ask the department. Okay. Thank you. Every year, department is evaluating demand entitlement, right? In that demand entitlement, you review this reserve margin and how much firm capacity company has to procure. Was there any analysis connecting these two concerns? Because I think we had that significant concern during the Winter Storm Uri investigation, and department did a great job there. But are you doing this regularly to see whether this interruptible customer is paying fair share?
And I'm going to have to ask Ms. Campbell again to address that issue.
I'm not sure if I know that right off the top of my head, so I think we'll have to take that back. I can talk with people on my staff, like John Kundert and stuff, to take a look at that. I think we think that it's a fair split, that they get a discounted rate for interruptible customers and stuff like that, to be able to make room on the system when it's tight. But we can certainly look at, and I understand your idea about the revenues and making sure those come back to first firm customers.
Thank you. I hope department is analyzing this in the PGA and then annual demand entitlement.
Other issues here? Commissioner Tuma?
Yeah, Madam Chair, I do want to dive into a separate issue on page 5 of the settlement. There is a discussion about the prepaid pension. And me and Mr. Mueller had a conversation about this when MP came through with their settlement before apparently they chased Mr. Mueller out of MP, but no, he moved on to a good job, so I don't want to give him a hard time when I can. But and so I kind of want to have that same conversation with you all and understanding this settlement. So I read the language of the settlement. It says the settling parties agreed that should that appeal result in a reversal or modification of the Commission's 2021 electric rate case order, with regards to prepaid pension assets, the company shall be permitted to include pre-pension assets net aided in the final revenue requirements, or recover the net amount through rates accordingly. And so the court didn't give us a reversal or modification. They gave us a remand to look at specific factual issues, determining whether the prepaid pension is a shareholder asset or a ratepayer asset. And we have to do some work on that. I assume in the Xcel rate case has been remanded to us. We'll, I think, have final determination, or I guess the appeal is going to run here soon, and then we'll deal with it after that. But given the fact that it's not a reversal or a modification, I want to know your understanding of what that means for this case. And I guess my sense is that we'll have to see what results out of the final Xcel electric rate case, and then something has to be done or filed or dealt with either in the next rate case or in this rate case as a miscellaneous filing. So give me your understanding now. What would happen after we finally resolve the electric issue? How does this come back in front of us in this rate case?
On prepaid
thank you,
pension.
On prepaid pension, yep.
Thank you, Chair Stephen, Commissioner Tuma. I think we're thinking about it, speaking for the company, I think very similarly to how it was addressed in the Minnesota Power case, in the sense that the appeal time has not yet run, so we don't know exactly what the next steps will be. But in the event of a remand, that could be addressed at that time, and the Commission could make some determinations at that time about how best to address it. In this case, it potentially would need to be taken up, but it doesn't necessarily need to be taken up in the sense of an immediate change. There could be something like a deferral, as staff suggested in the briefing papers, as a way to manage a change should there be one.
My guess, and then each one of these where this question arises, there's going to have to be some specific, fact-specific determination regarding how this rolls out, and so there's going to be have to something that happens. You're just going to tell us what that is after you see how the final Xcel electric rate case works out, is what I'm hearing.
I think that's correct, Commissioner Tuma.
Because who knows what the facts are in this situation compared to the facts in that situation.
Right.
And are you going to ask the other parties if they agree with that assessment? Great.
That's you're tracking. So I'm looking particularly for our OAG and department, how they view this analysis, what we're going to be dealing with now that it's remanded and not necessarily modified.
We agree with the way Ms. Brahma and the company have described what they anticipate. We have the same anticipation.
OAG.
Commissioner Tuma, the OAG actually did not have testimony on prepaid pension asset in this case, so we deferred to the department on that. I will note that the settlement regarding executive compensation, which was also part of the appeal, that won't change either way.
Commissioner Hom.
Thank you, Chair Siebert. The follow-up to this discussion, rate case is holistic. I think everybody agree in the beginning that this settlement is a holistic settlement. How can we separate out prepaid pension out of the whole rate case and we can deal with it from the company?
Ms. Brahma.
Thank you, Chair Stephen and Commissioner Hom. Our view is that that is part of the holistic settlement. It's not that it's being separated out. It's that this is something that was somewhat unknown to the parties at the time the settlement was reached in terms of how an appeal would go. And obviously, it's been an issue that's been of some debate for some time. And so to let the appellate process play out and at this point, any next steps following the appeal process is part of the sort of holistic solution that the parties reached in the settlement.
I understand that was probably a solution, but how can we deal with this issue outside this rate case as a single item subject to the decision on the other case while we are already fixing ROE, your capital structure, and everything? Because as you said, everybody agree, rate case is not a single item issue. It is a holistic decision on your revenue requirement and recovery of it. You just single out one item from the whole decision-making process and making financial decision on that one. I'm not saying that you made a decision on that item and you agree on that issue, but you haven't decided financial issue on that issue. That will be decided outside this financial issue decision we are going to make today.
Thank you for the question, Chair Sieben, Commissioner Hom. The issue, I think, is that in part, settlement is not only about the dollars and cents at the end of the day. Obviously, that's critical to it. But also as part of it, and this is a part of the issue that was before the Court of Appeals, is what assets the utility has a right to recover or earn a return on and so on. And so, yes, that will affect potentially the financial outcome on some level. It's a relatively important but not enormous piece of the puzzle. But this underlying question also needs to be resolved, and that's based on the record. And the Commission, the Court has given the Commission some direction in the electric case about how to address it. But I think that's true whether it's a settlement or a Commission decision, as in the electric case. There are going to be occasionally some issues that come up as a result that come back to the Commission to decide. And the parties here decided that this was the best way to address those questions, both financial and the underlying issues, for purposes of this proceeding.
Okay, thank you. If I may ask, Department.
Mr. Mertz.
In my view, if Department thinks this a prepaid pension or pension expense is expense, and deciding the value of expense outside the rate case is it reasonable? Because in the typical rate case, we allow utility to have a reasonable expense built in, and then right amount of the rate base built in, and then we approve revenue requirement, and utility has a right to recover that amount. We do not guarantee them to recover that amount, right? That's the principle of this regulated utility rate making. Under that, we are taking this one issue out of this rate case financially, not about what is a rational settlement, but taking this one expense out of this case, and how can does ratepayer have any recourse if we have a different decision over there? And we celebrate that this is a good decision here, but if there's a huge expense because of that single issue decision outside this rate case.
So, thank you, Chair Hom. I would, first of all, echo what Ms. Brahma said. I don't think that we're really taking this issue out of the rate case. What we did was agree on a resolution that allowed the parties to resolve the case subject to some decisions that are going to be made by the Commission down the road. Now, that's going to be true when you end up dealing with that issue in the context of the MP and Xcel Electric case. And I don't think you would say in those situations that you're taking the issue out of a rate case. What you're doing is you're establishing some ground rules for how you're going to deal with these issues, and you're going to be looking at the facts that allow you to come to a conclusion about whether this should be treated as an asset on which they're entitled to a rate of return. So I would not say that we're taking it out or that we're taking it in isolation. What we're doing is saying this issue is going to be resolved in the future, but for purposes of moving on today, this is a reasonable way to resolve it. We're going to decide to apply what the Commission decides on a going forward basis.
And if I can just jump in, Mr. Mertz, like the commission already made a decision on how to treat prepaid pension assets. Parties appealed that decision, and now we're still in the throes of the appeal process. And so the understanding I have from how prepaid pension asset will be treated in the future is we have to let the clock run on whether the parties will appeal. And then if they don't appeal, then one process will be set in motion. If they do, we'll have to wait a little longer. But regardless, the commission is going to have to come back and discuss this issue more and kind of help resolve how to handle it for these existing cases on a looking back method, and then also how to treat it, prepaid pension assets in the future. Is that generally consistent with what your position is here, or what you recommend how we approach this topic?
Yes, Chair Stephen, I think the way you described it is exactly how we're viewing this issue.
Okay.
Madam Chair, along that lines, we've removed it out of here, so it's not in this test year. Prepaid pension is removed, and so that's what gave you comfort. I would assume in settling it, we might have to put money back in, but as the old saying is, possession is 9/10 of the law, and so right now the ratepayers are the ones possessing the dollars. They have to come to us, prove to us, in fact, in this case, as in the electric case, that it is reasonable and prudent and within the appropriate accounting for a utility to count this as a base cost of doing business.
Chair Stephen, Commissioner, I think that's right. I agree.
So, I think that's what gives me comfort, at least at this stage, where we sit with this particular rate case. At least the money is now in the ledger for the ratepayer as opposed to the company, and so they still have the burden moving forward. I would assume that you agree with that, Ms. Brauman, that you're gonna carry the burden in this rate case just like you would in any other rate case.
I think that's all dictated by the Court of Appeals decision and the law as it currently exists. And so we agree that it makes sense that it's in the customer's hands right now, and the commission's processes will establish the next steps.
And to the OAG's point about, or someone made the point about top 10 executive compensation, that was also subject of the appeal that we were talking about with prepaid pension. But for that issue in this rate case, as part of the settlement, there was a cap that the parties negotiated with the utility. And so for the rate case here, that issue is settled in your minds, correct? Or that was the overall feel I got from the settlement, right, Mr. Attorney?
Chair Stephen, that's correct.
Okay, thank you. Any other discussion? Commissioner Hom.
Thank you, Chair Stephen. It's about the capital structure for the company. Okay, NSP Minnesota is a wholly owned subsidiary of the Xcel holding company, right?
Madam Chair, Commissioner Hom, yes, that's my understanding, right?
So you are not issuing your own stock to the public, and equity is injected by your holding company?
Yes.
Okay. What is your current cap structure of the equity portion of it?
Chair Stephen, Commissioner Hum, are you asking what was in the settlement or what the actual capital structure is today?
No, hypothetical structure. We are about to approve whatever we are making decision from now on.
Yeah, thank you. That's 52.5%.
Thank you. So what is the rationale that you pick that number?
Madam Chair, Commissioner Hom, that is the capital structure that there's a couple of different reasons. We certainly have a number of testimony on it. That is the, the capital structure that we have used in previous cases that the Commission has approved, and it also reflects the company's actual capital structure in the market, as I understand.
Okay. Thank you. I mean, because we made that decision in prior rate case doesn't mean that we have to make same decision here, right? Do you know what is your debt equity ratio of the holding company?
I don't off the top of my head. I believe we do have Josh Novak on the line who may have reviewed that as part of his testimony.
He's online. Oh, I see. Mr. Novak, welcome. Could you please state your name for the record?
Joshua Novak, Nowak. And as to the question about the equity ratio or the capital structure of Xcel Energy, unfortunately, that's something I did not specifically opine on in my testimony. I don't know where that stands today.
Okay, so I do my own research before rate case. I saw that 1.5 and above. Can you tell me it is about right or is it totally off?
I'm sorry, it's a statistic I have not reviewed. I was focused on a review of the subject company itself,
okay.
And looking at NSP on a standalone basis.
Okay, thank you. So if your holding company is not holding up the 50-50 equity and debt ratio or the even 52.5 or 6 equity ratio, there is a potential double leverage that holding company borrow money and inject that as equity to the company, and we are paying higher return on that one. It's a hypothetical.
The holding company is going to have different financing needs and is going to finance it according to its needs. It may have unregulated subsidiaries. It may have regulated subsidiaries. So there's varying reasons why those capital structures may differ. Ultimately, what is infused to the subject company may be cash is fungible. It's not clear exactly where a dollar raised at Xcel Energy, how that traces through to the subject company.
Okay, so do you think NSP Minnesota is ring-fenced from the holding company's financial behavior and their credit rating?
I'm sorry, I'm not sure I understood the question there. Could you rephrase, please?
Okay. Do you think NSP Minnesota is completely ring-fenced from the impact of Xcel Holding Company's financial behavior or financial credit rating?
I mean, completely ring-fenced is a bit of an extreme. I mean, to a certain extent, NSP's financial integrity will be influenced to a certain degree by Xcel Energy. So no, I couldn't agree that it's completely ring-fenced.
Okay, that's why I had a concern with the potential double leverage and the behavior of the holding company, which will take a more risk, debt, and injecting that as a potential as equity to the NSP Minnesota. And even though we approved more than 50% of the hypothetical capital structure prior, but in practice, Xcel Energy Holding Company is doing something very different from that may have a negative impact to NSP Minnesota, even though we try to protect NSP Minnesota credit rating.
Mr. Nowak?
I would say the financing practices of both NSP and Xcel are very much in line with industry practice. It's a very common arrangement in the industry for the operating utilities to be held by holding companies, as NSP is, as Xcel is. And my analysis was focused primarily on, is NSP's capital structure consistent with other operating utilities? And I found that it is. Other operating utilities that are also held by holding companies that have different financing needs and are financed in according to the business segments that they own. As to the protections in place at Xcel relative to the operating utilities, again, my understanding is it's very much in line with the operating utilities. As to whether or not there is any issue with the company raising debt to finance equity. Again, it's common for the holding company capital structures to vary considerably from the operating utilities. I'm familiar with holding companies having equity ratios that are closer to 40, 45 to 50%. So as I see it, what Xcel is doing is very much in line with industry practice.
Okay. So, I mean, I mentioned this in the Xcel Energy Electric case, I think interim rate decision-making process. This might be the time that we have to revisit everything, including cap structure and depreciation and everything, because we are in the process of changing a lot of things in this industry. And also now utilities are asking for a prepaid pension as an asset. I think that this is a time to revisit the capital structure, because now they are trying to create more asset out of the expense, and that this might be time to revisit the capital structure issue. So I'm not suggesting that I'm going to do it here, but I think I'm just giving you, I think, heads up that I'm going to look into it. I need to see more record on it.
Very interesting.
Okay, are we ready to move to deliberations, commissioners? Staff, we're good? Anything else? Does someone want to make a motion? Commissioner Tuma?
Sure, I think I could try to make a motion here. I think it is decision option. Let's get to the decision options. 1, and then 115, not as a change to the settlement, but just as a minor technical modification to some grammar that I don't understand, but it seems to say the same thing, change. And then we would adopt 901, 901A as proposed by the Department of Commerce, 903, 904, and 905. Is that correct, Ms. Marcus? Okay, she's nodding her head, yes.
And the parties all agree that that's consistent with approval of the settlement?
The department agrees, yes.
Yes.
And Madam Chair, I appreciate the discussion on the ROE. Typically, I'm the ROE hawk, and I definitely would have had a smaller ROE recommendation had it come back in front of us. And I probably would have dealt with some of the other issues on how the apportionments were done. But, I think everything here was within, I would say, appropriate guidelines, guideposts, I think. Sometimes you could have a settlement that maybe a particular issue is a little bit outside of what I would think is appropriate, but it's balanced out by something else. But I don't think we needed to go there. I think everything was kind of within appropriate guardrails, and so I'm satisfied that we should approve the settlement given the parties' positions. But I appreciate the discussions we've had so far, and recognize that we still have a little bit of work when it regards to prepaid pensions, and there'll be quite a bit more work on that, I assume, on a lot of cases as we deal with it. And I really do like the suggestion Commissioner Hom had about maybe having to revisit how we look at the capital structure, given some of the assets that they're trying to, or claimed assets they're trying to put in to that space. And so I'm pretty satisfied with it, so that's my motion, Madam Chair.
Thank you. Is there discussion? Commissioner Hahn.
Thank you, Chair Siva. I'm very critical of today's discussion, but that doesn't mean that I'm criticizing your settlement. I will support the motion and I'll support the settlement. I understand it's holistic, everything. Ratepayer doesn't care each component. The ratepayer wants to make sure that they are not paying any single penny above they need to pay. So I appreciate your work, but also I want to see more detailed work in public, because maybe we know, but public may not know those details and they may misunderstand what is going on in here. So I think sometimes we may have to be overdoing rather than underdoing, informing public on this your process. So that's why I was asking some of those questions to making sure that we need more record to the public we owe them to make sure that they are understanding what we are doing.
Okay, on Commissioner Tuma's motion, Commissioner Hom,
Yes.
Commissioner Tuma,
Yes.
Commissioner Sullivan.
Yes.
I vote yes as well. The motion passes 4-0. Thank you very much, everyone. There's no other business before the commission, and we'll see some of you next week. Have a good